said, I still believe in the stars and bars.
Yes, I remember that at one time, the commemorative Air Force
Yes.
was actually called the Confederate Air Force.
No, my dad was born in Alabama, and the Alabama flag is white with the red stripe through it. I wanted to put something on me for him, so I just put the stars and bars.
Oh, no, that's a rental deal right there.
That's,
Hey, it's part of America.
yeah,
It's our history. This is very much a part of our history. It's the Revolutionary War.
yeah.
Which was less than I thought it would be.
But I do think that some of the poison they spew is.
That's what that guy's good at. He's a worker.
I only join because sometimes they give away. I only join when the years when they're giving away really good gifts. So I have lapses in my membership. Oh, the gift's not that good this year. I don't want to join.
All right. All right, we're going to call to order the June 3rd meeting of the Planning and Zoning Commission. Start with the Pledge of Allegiance. Corey, would you like to lead us?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, the next item on the agenda is roll call.
Commissioner McCauley.
Here.
Commissioner Edmonds.
Present.
Commissioner Pasiak.
Here.
Commissioner Mendoza.
Here.
Commissioner Merritt.
Here.
And Commissioner Rowich.
Here. First item on the agenda is minutes, consideration and possible actions to approve the May 6, 2014 Planning and Zoning meeting minutes. Everyone had a chance to read them?
I move the minutes be approved.
Second.
Any comments?
No.
A motion and a second. All those in favor?
Aye.
Aye. Motion passes unanimously. Item 5 is staff report.
The only item for staff report is we will not be having a meeting July 1. I'll be out of town, so there's no purpose in having one. We don't have anything prepared for the agenda either, so just FYI, you're off the hook.
Okay. Item 6A, revise and relocate the subsections of Section 5.5, modification appeals and enforcement to the appropriate sections of the UDO, and strike those portions that contradict Arizona revised statutes, town code, or other portions of the UDO.
Good evening, Commission. Before you, you have the final version of the modification appeals and enforcement, Section 5.5 of the Section 5 of the UDO, which is the subdivision regulations. We've discussed this at length. Again, briefly, there are portions of this that grant authority to the town manager to override town council, which is in direct conflict with state law. There is language that needs to be cleaned up because it's not clear, and you will notice that the attorney has stricken paragraph A under 5.5.1, and we have replaced it with the language that is straight from ARS for what exactly town council can do in considering subdivision plats. So if there are any other questions, I'd be happy to answer them. Yes, sir.
I just have a question. Is there a provision for a public hearing so that if they're making changes, abutters are aware of the changes that would be proposed?
In terms of the subdivision, there's a whole process for public hearing before that we even get to this part.
Thank you.
So,
You got a minor typo on established.
Right.
yeah, I saw that, yes. That's Lois, or I'm not Lois, that's Phyllis.
Shame on Phyllis.
I know it. But spell
Thank you.
check doesn't work in caps, so.
Any other questions?
This wordage brings us in complete compliance with the state regulations now,
For this.
for this item.
Yes, for this
Yeah.
one item. There are other things that we will be fixing still, but for at least Section 5.5, the town manager no longer has the power to override town council, which he shouldn't have in the first place, so.
And one other clarification, on the last paragraph,
On 5.5 Enforcement B,
Uh-huh.
if I got my note at the right place, that is strictly for the subdivision only. It's not for all the UDO, correct?
This is division of real property, right, only for this portion of the ordinance, only
Okay.
for the subdivision.
Okay. Thank you.
Yep.
Okay, as this is a public hearing, we will open the public hearing. Is there anyone here that wishes to speak? Okay, seeing none, we'll close the public hearing. If there's no further comments, Chair will entertain a motion.
I'll make a motion that we forward the proposed text amendments to the UDO Section 5.5 modification, appeals and enforcement, parentheses subdivision requirements to the town council with a recommendation for approval.
Second.
I have a motion and a second. All those in favor?
Aye.
Aye.
Motion passes unanimously. Item 6B is a public hearing to take comment on proposed text amendments regulating the manner and placement of special purpose residences, such as sober houses and recovery homes, assisted living homes, and assisted living centers.
Again, Commissioners, we have discussed this sober home and the assisted living facilities and nursing homes at length. Again, the purpose of this is to regulate the manner and placement of the sober homes. As I'm sure all of you are aware, the Prescott area has quite a recovery population and industry going on, and these homes are not necessarily regulated by the state, so it's important to safeguard the existing community and regulate their placement within the town of Chino Valley. Again, the occupants of the sober living and recovery homes have to be sober. They can't be using drugs. If they are, it invalidates their qualification as disabled under the Fair Housing Act. So the minute somebody relapses, or whatever you want to call the technical term for it, they are no longer protected under the under the Fair Housing Act, and are no longer protected by the rules governing those residences. In terms, I know we've had some discussion about sex offenders, and I want to be clear about how this works with the sex offenders. If you are a sex offender and you are seeking treatment for that, that is not protected by the Fair Housing Act. If you are a drug addict who has been put on the sex offenders list and you are here for drug addiction treatment, it's the drug addiction or the alcoholism that qualifies you as disabled. However, you are also required under the, oh God, what's the name of the act? The Sex Offenders Act that regulates both, the state has a set of rules, and the federal government, or the federal Justice Department also has regulations and laws governing where sex offenders can go. The first thing they must do when they come to a community is register with the police. If they don't, they can face up to 10 years in prison. So the onus, in addition to the language in here, the onus is on that person to register in the community, and it's also on the sober home to make sure that they register, because they have to be aware that this condition exists. In terms of the assisted living facilities, the language in the UDO is somewhat outdated, as it discusses only nursing homes. It doesn't talk about assisted living facilities or assisted living homes. So staff went through, reviewed the definition of those uses in the Arizona Department of Health Services regulations to make sure that what we have is in agreement with what they require in terms of populations and the number of residents and so forth. That language has also been added to the definitions. In terms of where we suggest that these uses be added, we have left the sober homes out of the mobile home designation in discussions with the police and other municipalities. The understanding is that those tend to be higher crime areas and higher drug use and alcohol use areas. The police tend to have more of those related calls in those areas than others. So it would be kind of defeating the purpose to put one of those homes in a mobile home park. We did add them back into the multifamily residential zoning district because the discussion that we had regarding number of people per unit really doesn't, or per bedroom doesn't apply here. The HUD standard is a 7 by 10 bedroom, but they don't regulate the number of people, and those rules only apply if you're using HUD financing. And whether or not somebody uses HUD financing is an issue for them to settle with HUD, how they meet that standard. We're only regulating the manner and placement. So the recovery homes and the assisted living homes would be allowed in the multifamily residential. Staff recommends forwarding these proposed text amendments to Town Council with a recommendation for approval, and I'd be happy to answer any questions anybody has. Yes, sir.
Yes, on the multiple family residential that we just talked about, and the current UDO, it's listed as a conditional use being in there, and this one here you have is permitted. Why the change?
Because if we're going to have a concentration of a multi-family or a multi-person facility in a multifamily residential district, that's a better location for it than to put something with a lot of people in it. If you have a 4-bedroom home, to put 2, 4, 6, 8, 10 people in a single-family residential location. So the point is to try to encourage the location in the multifamily residential rather than the single-family.
Okay,
It makes it easier for them to build those sorts of things and monitor them there.
okay, thank you.
I have a similar question about having a multifamily residential. And my question at the last meeting was that if you have it in a multifamily residential, it could be in a condominium. And
Correct.
it could also be in an apartment complex.
Well, a condominium is a form of ownership. So if you're talking about a townhouse or something like that, or in an apartment, the point of these recovery homes is to integrate people back into society. So,
And my question at the last meeting was that wouldn't it be problematic to have it where you have an apartment complex, let's say with 20 units, and one of them turns into a recovery home? What would that impact be with the 19 other apartments?
it shouldn't be any impact at all, because these people are no longer using drugs or alcohol, and they are monitored.
I still have concerns about it.
Okay.
The other item is that second paragraph from the bottom on the first page of 6B says, during the discussion of this item at the June 6th,
Right.
Yes, it should be May.
just a typo, so.
Well, while you're talking typos, you got section 4 twice. You have for procedures, and then after standards, you have number 4, request for accommodation.
I'm sorry, which page is that?
It'd be actually the next to the last two, next to the last page and the last page. There's no numbers on them, so I can't. You have on top of the one.
Oh, I see what you're saying. Yes, that should be 6.
Okay. That way we don't have to go through this again.
Any other questions for staff? Okay, this is a public hearing, so we'll open the public hearing. Is there anyone in the public that wishes to speak? Seeing none, we'll close the public hearing. Any discussion? I'm not opposed to regulating group homes. I think the conditional use permit is a great way to do that.
I have a question. If one person in the building or home is found to be using drugs or alcohol, they're removed from that facility, but does that affect the total facility in any fashion?
It removes that person from that facility. If there is an instance where we have repeated problems with that facility, we can require them to come up with some sort of mitigation plan as a part of their business license. They have to renew their business license every year.
Do we have some sort of a limit? In other words, if you have 5 incidences or 2 incidences?
No, we didn't set a limit because we want to make sure that if there is some issue where we have 3 at once, we can say, you're not doing your job,
Right.
that's it. You
So
need
that
to
would be
mit-
counted as 1 incidence then?
Well, we could count it as 1 incident, or we could say, if this is the 3rd time you've had 3 people, OD in your alleged recovery home, you guys are now going to lose your business license unless you straighten up and get a mitigation plan in process.
And how are we monitoring these?
The
places?
state, I'm sorry, we monitor them through the business license process, and the state does do some monitoring of them. So if we go in and say, when's the last time you've drug tested everybody, they have to come up and tell us when they've been drug tested, are we having any issues? If we get complaints from neighbors,
So we have the ability to come on site and
Yes.
request documentation?
yes, that will be part of the application.
I would think we could revoke a use permit as well.
Yes,
Okay, so
and we
we
can
have-
also, right, and that language would be in the use permit, that if you don't comply, if it's someone who has a past history of having these homes in another community, and they have issues in these other communities, we can say, 1 strike and you're out.
So we have some teeth in this that we
Yes.
can actually do something
Exactly.
besides pull their business license.
Right, and this is why we did this as a conditional use permit, because we now have to have public hearings, the surrounding neighbors will know what's going on, if they have concerns, if they want, nobody coming in and out after 10 o'clock at night. Those are the conditions that we can put on a conditional use permit.
Okay. Will this be the duty of code enforcement to monitor this?
Yes, and the police, if it gets too rowdy. Anything else? Yes, sir.
I need a little clarification, please. So are we saying that all these sober houses are regulated under a conditional use permit, or are we going to give them permission to be?
The ones that we have set out in the conditional use permit use will be required to get a conditional use permit. The only ones that are not required to get a conditional use permit are the ones in multifamily and the ones in the commercial light. I believe is
Right.
the other one we added it in.
So, but I guess my difficulty is, why are we relaxing the standards for a location for these? I think, are they not held to a higher standard with a conditional use permit? That way everybody knows what's going on around them?
Yeah, I understand what you're saying. First of all, we don't have that much land that's zoned multifamily housing. So if someone were to come in and buy a piece of property that is currently zoned SR2, they either have to do a conditional use permit or get it rezoned to multifamily if they want it as a use by right. Part of that process for rezoning is a whole series of public hearings and neighborhood meetings prior to any rezoning action.
But is there any protection for current multi-residential?
You mean, like if we had somebody that found a parcel of land that's currently zoned multifamily residential, it's a use by right?
Or we have property in town that's multi?
Right. We have
So-
very little right now.
Right, but if somebody were to come in there and say, I want to open a sober house,
Mm-hmm.
are the abutters notified?
Are the
Or-
surrounding property owners notified?
Yeah.
No.
Okay,
Not as
so-
part of our process.
So you could wake up one morning and go, oh my gosh, what's next door?
You could, but the
Is-
odds of them having anything that's going to be, first of all, we've limited these in terms of separation. We have a 1 mile
mile,
separation
right.
between units, so we're not going to have that many in town.
I was just
Unless council relaxes that. I'm just trying to put this in perspective.
Right, I understand.
In terms of the multifamily housing, like I said, we have very little existing acreage that is zoned multifamily. So as of today, if town council passes this, there are probably 4 sites in town that would be able to take advantage of the use by right status of an existing multifamily property. That's it. Anybody that gets rezoned after now could not possibly beat this to town council with a rezoning action, given the statutory publication and notification requirements.
I'm just wondering if there's any process for notifying people that may be affected by this.
Not in a multifamily or a commercial light, no.
Is there a way we could add some language that would allow them to have notice that this type of activity is going to happen next door to them or in their same building?
We could probably do it as a condition of the business license or the application and require you to notify everybody within 100 feet, but it really isn't going to make any difference because it's a use by right. I mean, they're entitled to that use by that zoning.
So we could not restrict them no matter what, because the zoning already says that they're able to be there.
For the existing multifamily properties.
And commercial light.
And commercial light, right, that's exactly right. And those are the places that we want to see these because they're a higher density use rather than in single-family neighborhoods.
Right. I'm just anticipating questions down the road.
Oh, yeah, no,
When
that's
people
fine.
go, the sky is falling.
Right.
We should be
And
able
you
to
can say,
well,
well, it's not really, if you go look at the zoning map, there
Exactly.
aren't that many multifamily zoned properties that aren't already built on, quite frankly.
Right, right.
But
So-
regardless, we wouldn't be able to do anything different than we are doing, am I correct?
Correct.
Thank you.
Yep.
Any other questions, discussion? Okay, Chair will entertain a motion.
I'll make the motion to forward the proposed text amendments regulating the manner and placement of sober homes, assisted living centers, and assisted living homes to the town council with recommendation for approval, and I might add, as written.
Second?
We have a motion and a second. All those in favor?
Aye.
Motion passes unanimously. Item 7A, election of officers. In accordance with Section 1.4.3 of the UDO, the commission shall elect a chairperson and a vice chairperson from among its own members.
It's pretty much self-explanatory.
Pretty
I
much
tried to get it all in the
self-explanatory.
title. When Gwen's absent, we need to be able to have somebody already lined up rather than calling poor Charlie at the last minute. Chuck.
Okay, I'd like to nominate Gwen as chairperson again, and Chuck as assistant chairperson or vice chairperson, since he did a fantastic job on a last-minute call the last time.
I'll second that.
I'm
Other-
curious
It's not too
on,
late to run, Chuck.
How does the council, I know where I am on the totem pole. How does seniority lie as it is right now?
I think Gwen is the longest-serving member, and as far as I know, I'm the second
You're the second.
longest-serving member.
Yeah, I'm 8 years. How many years are you, Chuck?
2 years, I believe. I just signed up
Right.
again.
Actually, I think Florence is the longest standing
Yes.
member, but she's not here this evening.
So it would be unfair to pin that on her.
I don't know that she would want to be chairman, though.
Well, she rides with you anyway, right?
She does. If she comes, I give her a lift, yeah.
I would suggest she would decline.
All right, well, that's not a given. Is there anyone else that has a desire to? I'm happy to continue if that's what the board would like, but if there's anyone
You've been doing a
else.
fantastic job, and like I said, Chuck stepped in the night you weren't here and did a really good job, and I think he should continue on.
Are you okay with that, Chuck?
Yes.
I just want to make sure before we.
I'm not sure I
before we
agree with the
vote you
good
in.
job part, but I would be honored to be the
You
vice
did a
chair.
fine job.
And I would be honored to be the chair. Is there any other discussion? All right, then all
You have
those
to
in.
vote. You have
All
to
those
vote.
in favor, we had a motion.
Okay.
All those in favor?
Aye.
Aye. Motion passes unanimously. All right, no discussion items. Are there any public comments? Any item not on the agenda this evening? Seeing none, I'll entertain a motion to adjourn.
Make a motion, we adjourn.
I have a motion and a second. All those in favor?
Aye.
Aye. I'll see you in August.
Is the way a meeting
Oh, that's right.
That's right.